Last week, the South African Parliament launched a program commemorating the 20th anniversary of the South African Constitution. The year-long program will see to events that will be rolled out as the year progresses. While the program is about celebrating the adoption of a democratic constitution in 1996, this gives South Africans an opportunity to create conversations on what this constitution represents and who does it represent and who's it for? Well, Professor Shadrack Ghutto joins us from our Pretoria studios. And Professor Ghutto, you will remember and recognize very, very well. He's a retired law professor and, of course, a constitutional law expert. Prof, good to see you. Welcome to the program.
Thank you very much, and to the viewers this early morning.
Oh, indeed, it is an early morning, it certainly is. But Professor, let's get straight into the meat of the conversation. What have been some of the most shining examples of a functional democracy emanating from our Constitution?
Well, I think it is important, although we say we have had two constitutions since 1994, the interim constitution which we used until the 3rd of February 1997. And then the new constitution, which we call the final constitution, came into effect. And it is very important for us to be able to appreciate what the new constitution, the permanent constitution, has done. First of all, it laid the foundation for a whole lot of laws which have been made since then and which were required by the constitution to be made. I think I can mention just about 4 of them. One is dealing with equality issues and prevention of unfair discrimination. We do have a legislation dealing with that. We do have a legislation dealing with promotion of just administrative action, PAJA. We have one dealing with a question of access to information. Then we have another one governing questions of procurement and how that can be used as a basis for trying to transform the economy and so on. So we have a good constitution in that respect.
Yeah.
And provisions which are there dealing with equality, with land reform and so on are there, although we haven't used it properly.
Indeed.
That is why there's a lot of fighting about how to amend it, but we don't need to amend it. We just need to interpret it properly so that we are able to transform land ownership and social transformation in the country.
Yeah.
So that is one aspect of the Constitution, a basis for making other laws, the Equality Act and so on and so forth.
Okay,
The
Professor, one second.
area where the
Professor, I'm going to interrupt you.
Yes.
Professor, if you don't mind, I'm going to interrupt you. We just don't have too much time, unfortunately. So if I can just ask you to keep your questions a little shorter so we can get more in. Recently, we saw the Constitution. It's being challenged a lot lately, and it's something that we've been following very, very closely. And South Africans do respect the Constitution a lot. But when we see the Constitutional Court hearing different cases and saying that our Constitution has been violated on different occasions, and I'll just give the Nkandla issue. That was one case that did come up. Now we saw this one that, of course, is hitting the headlines, that of the SASA case. That was in 2014, and we're seeing perhaps the service provider who has been declared unconstitutionally fit is now possibly going to be signed on again to do something, even though it's been declared unconstitutional. What do we read into these violations and why they continue to carry on?
We are building a constitutional democracy, not a parliamentary democracy. And from that point of view, even Parliament has to abide by the Constitution. I think that has been stated very clearly in so many cases that have gone to the Constitutional Court. And I think that's one point we need to understand. The fact that you have Parliament has to act according to the Constitution. The executive have to act according to the Constitution. So we don't create autocracy. The most recent case where the executive tried to withdraw from the International Criminal Court,
yes, the
court said, no, you cannot do so. That matter has to go to Parliament, because ratifying international treaties such as the Rome Statute was done, and it had to go to Parliament. And the executive was found was trying to bend the rules and begin to make decisions which should have gone to Parliament. So the courts are there also to create checks and balances to ensure that the executive doesn't abuse the Constitution. Parliament has a role to play, but there are also a lot of cases which have found certain legislation not to conform to the Constitution. So there again, Parliament is being punished for not obeying the Constitution. So there are a lot of cases where, for example, the president had wanted to extend the period of a chief justice in the country. The president was told, you don't have such powers, and so forth. So we do have checks and balances, and the Constitution, any act or law which does not conform to the Constitution is unlawful, invalid, and cannot be used.
All right.
So that is the strength of the Constitution that we have.
Oh, Professor, I wish I could talk to you for so much longer, but unfortunately we need to wrap it there. But thank you for talking to us. Professor Ghutto, Shadrack Ghutto, is a retired law professor and constitutional law expert, talking to us about the importance of our Constitution. And I think you gathered from there, it's the checks and balances in our Constitution and the courts of law that are enabling us to abide by it. So that's just some of the views out of that one. Right, let's quickly get to a weather update.